Well, hello everyone, and welcome to One Civil Law, where as always we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court. And we are here today with a decision from the District Court in the case of LM versus Nicholas Middle School. LM is a student at Nicholas Middle School who wore a shirt to school one day saying there are only two genders. The school ordered him to remove the shirt and not wear it. He refused, so he was sent home for the day. He then wore a shirt to school saying there are censored genders. The school ordered him to remove that, and a lawsuit incurred. The student argues the school is prohibiting his free speech, namely that the school allows messages that promote, encourage, extol, extend the virtue of the LGBTQ question mark ampersand divided by sign squiggly mark contingent, and he, with a different view, is not allowed to express his viewpoint. Now, this sounds suspiciously like viewpoint discrimination speech, which is really, really bad, right? When we think about the constitutional hierarchy of things and when the government can and cannot regulate speech, we come in kind of different tiers as it relates to such things, right? If the government wants to just regulate time, place, and manner of speech, we think intermediate scrutiny. If the government wants to ban an entire subject from discussion, then we think strict scrutiny. And if they want to allow the subject, but only allow certain viewpoints relating to that subject, we're thinking strict scrutiny plus, perhaps per se unconstitutional. Okay, so the district court has to decide whether this is protected speech, the shirt, and whether or not the school is infringing his rights, which it seems like it is, based on Tinker and BL versus Mahoney, where we've dealt with this issue before. And it seems like yes, the students do not give up their speech at the schoolhouse gate, to quote Tinker. Exactly. So we're going to read this decision from Massachusetts District Court and see what it has to say on this fun, exciting issue. All right, let's see how this goes and what they seem to think. All right, let's add that stream. Okay. We are in the District Court for Massachusetts in the case of LM versus Nicholas Middle School, a school located in Massachusetts. Let's read more. The plaintiff, LM, is a minor, by and through his father and stepmother, alleges violations of the First and 14th Amendments by the defendant town of Middleborough, the Middleborough School Committee, and two school administrators. Okay. Nicholas Middle School is a public middle school in Myrtleboro, Massachusetts, which is to say the school is the government. Okay. The defendant, Carolyn Lines, is the superintendent of the schools, and the defendant, Heather Tucker, is the acting principal of the school. Okie doke. Student survey data shows that in June of 2022 at Nicholas, show over 20 individual student comments about perceived bullying at school, feeling unwelcome at school, and expressing specific concerns about how the LGBTQ plus minus side divided by ampersand squiggly mark contingent is treated at school. Okay. So a lot of LGBTQ question mark people think that they have received bullying at school. Okie doke. The school is aware of several of the students, including members of the contingent, having attempted to harm themselves or have thoughts of harming themselves, and these situations have frequently cited the status and treatment as major factors, which is debatable at best on the literature. But yeah, basically, this is emotional blackmail, right? The students say, if you don't give me what you want, I'm going to hurt myself. So give me what I want. Big time emotional blackmail. Fine. In July of 2022, one Middleborough High School student did harm themselves. All right. Before assuming the position at the Nicholas School, Tucker had met with parents of students and school students themselves who had been bullied because of lack of acceptance of gender identity. Okay, we're going to say this is all due to bullying, right? We don't want the students to be bullied. The safe space. So we can't have certain viewpoints because of bullying. Okay. The Tucker has also worked closely with students who have been hospitalized for attempted harm or self-harm, who have attempted self-harm because of gender identity. Tucker is aware of several students at the school who identify as transgender and non-gender disconforming. I'd like to remind everyone once again that this is a middle school. For those of you not familiar, and I actually don't know what the age range here is, because different ages in different kinds of middle schools, depending on how they draw the lines. But typically 6th to 8th grade, which means you're talking about 11-year-olds to 14-year-olds or 15-year-olds, something like that, maybe. Yeah, no, the 13-year-olds. You're talking about 11 to 13-year-olds, give or take. Something in that range. Maybe a year earlier, maybe a year later, depending on where the school district draws the lines about what a middle school is. But 11 to 13-year-olds plus or minus one. Okay. And we have students apparently of the 11 to 13-year-olds who believe that they're a transgender, and the school's like, yes, you are. And they say we're being bullied against because the transgender. Okay. So that's apparently what's going on that. Yeah. All right, fine. In January of 2022, May 2022, and January 2023, teachers and staff at the school received training to a further goal of providing support to students who are part of the LGBTQ question mark 2A animal spirit ampersand upside down question mark contingent. The school also observed events like Pride Month and Pride Day in support of the community. So I will take note here that the school has apparently a viewpoint that they are expressing. Gays are good. That's their viewpoint, apparently, that they're expressing with their speech. Okie doke. The school has a Gay Straight Alliance Club since 2018, again, the middle school, to further the goal of providing support to students who are part of the LGBTQ question mark, squiggly, at sign, asterisk, asterisk, asterisk contingent. Okay. The club is a student-run organization that's intended for space of students who fit under the umbrella or the allies. Generally, approximately 10 to 20 students attend the club meetings at the middle school. Each year, students and family are provided with the middle school students and family handbook. The handbook includes a code of conduct with a dress code. The dress code provides, in relevant part, the following. It expects all students to conform in the following ways. Clothing must not state, imply, or depict hate speech, which, by the way, there is no such concept in law. I'd just like to point out, at least in federal law, there is no such concept as hate speech. So saying hate speech is a meaningless term, at least in federal law. There is no such concept. We don't know what we're talking about. Because what is that? So I don't know if Massachusetts has a different definition or whatever, but hate speech, whatever that is, or imagery that targets groups based on race, ethnicity, gender, sexual orientation, gender identity, religious affiliation, or any other classification. When you say target groups, presumably you don't mean that affirms those groups, which presumably also incidentally would literally be targeting. I mean, just, from straight definitions, right? If I were a speech saying the gays are great, that is targeting the gays. That is the target of the speech. That is the subject of the speech, right? The target of the speech. Now, it's a positive speech, presumably, but it doesn't necessarily make it any less a target. But presumably, we mean target in a negative sense. Or any other apparel the administration deems to be unacceptable to our community standards will not be allowed. Uh-oh. Yeah. Okay. The First Amendment would like to have some strong words with you when it comes to that issue. The entire point of the First Amendment, lest I point out the obvious, is to protect unpopular speech. You don't need a First Amendment to protect popular speech. Why would you need a First Amendment to protect popular speech? It's popular. Everyone likes it. It's supported, right? So the First Amendment is its only value is to protect unpopular speech that's controversial. Otherwise, the First Amendment's kind of pointless. So it's like, okay, we're not going to allow any speech that undermines our community standards, which is another way of saying is not popular, is not accepted by our community, which is the entire point of the First Amendment from first principles. So, Okey doke. Yeah. All right. The dress code further states that if students wear something inappropriate to school, they will be asked to call their parent guardian to request they bring more appropriate attire to be brought to the school. Repeated violations will result in disciplinary action. LM, for his part, is a 12-year-old at the middle school. So presumably he is a seventh grader. LM and his father both signed an acknowledgement form at the beginning of the school year, reflecting that each understands the policies contained in student parent handbook, and the student is responsible for following the regulations and policies. Okay, I mean, get all the signatures you want. It's pointless from a First Amendment position. This is what we sometimes call unconstitutional conditions. All right. The government can't get you to just sign away, especially because schooling and selfing is required. You're required to go to school, right? And so they can't, as a condition of that, require you to give up your First Amendment rights. Did no one read Tinker? Did no one read Tinker? It says specifically that students' rights do not stop at the schoolhouse gate. Is LM wearing a black armband? Maybe we could get him to wear that and see if that drives the point home. Have they tried that yet? Wear a black armband at school every day and see if they understand what that one means. You know, maybe versions of different shades of black in a black rainbow armband. Maybe that's the way to go. Lord have mercy. All right, pressing on. On March the 21st of 2023, LM attended school at the middle school with the message, there are only two genders. While MM was participating in gym class, the principal asked LM to come speak with her. The principal informed LM that he could not wear the shirt because of complaints, and he could remove the shirt or discuss it further in another room. LM indicated he'd like to discuss it further, and he was escorted into another room where the school counselor joined the conversation. Oh, good. We're going to try to brainwash the student and tell him that he's the problem and try to convince him that his thoughts are destructive and wrong. How exciting. The struggle session is well underway, my friends. Okay, Tucker reiterated that some students and staff complained that the shirt made them upset. Well, I mean, okay. And LM needed to remove the shirt to return to class. LM declined, and Tucker called LM's father. Tucker explained to LM's father that he could not return to class if he didn't remove the shirt. LM's father picked him up from school, and LM did not return to class for the rest of the day. LM did not observe any disruption to school or activities by wearing the shirt, nor did LM observe any students complaining or appearing to be upset, which is incidentally, oh, and this is also good. LM also attests that he equates gender with sex and believes there are only two sexes, male and female. Okay. Yeah, fair enough. That's his view. So he thinks gender and sex are the same thing. And there's only two sexes, therefore there's only two genders. It's the same word for the same thing in his view of the concept. Okay. And now these last two lines are kind of important because Tinker talks about actual disruptions at the school, actual problems with the pedagogical environment is what we're looking for. We're not looking for stuff that is hypothetical or merely problematic. We're looking for things that cause an actual real disruption. That kind of stuff. Good times. Okay. All right. LM returned to school the following day and has attended every school day since then. LM was permitted to wear other t-shirts to the school, including one with the message, "Don't tread on me," First Amendment rights, freedom over fear, and "Let's go Brandon." LM was not asked to remove any of these shirts. Fun times. Good times for sure. Okay. On April the 1st of 2023, LM's father emailed the superintendent regarding the incident. LM's father asked about the substance and number of complaints lodged regarding the shirt and why LM was removed from the class, given the shirt simply stated LM's view on a subject that's become a political hot topic. A subject, incidentally, the school also has expressed its own views on. So that is notable. That is notable. The school has expressed its own views on the subject. On April the 4th, the superintendent responded that LM was not, nor would be the subject of discipline for wearing the shirt. He explained that Tucker sought LM's compliance with the dress code with lines supported where the content of the shirt targeted students of a protected class, namely in the area of gender identity, which, to be fair, I don't really think it targets the students. It's just an expression of an idea. but okay. An idea also, incidentally, once again, the school itself has no problems expressing in any way when it comes to their own preferred views. Elam has not been restricted from posting on social media when he's not in school. That does not solve the Tinker concern. On April the 13th, Elam attended a school committee meeting and spoke during a public comment period regarding the shirt. At the school committee meeting, Elam stated, "What did my shirt say? 5 simple words. There are only 2 genders, nothing harmful, nothing threatening, just statements I believe to be a fact. I've been told that my shirt was targeting a protected class. Who is this protected class? Are their feelings more important than my rights? I don't complain when I see pride flags and diversity posters hung throughout the school. Do you know why? Because others have the right to their beliefs just as I do. Not one person, staff, or student told me they were bothered with what I was wearing. Actually, just the opposite. Several kids told me they supported my actions. They wanted one too." Based. This student is pretty based. I respect this student. Shout out. Big time. Yeah, for sure. Good times. The statements have been broadcast on YouTube because, of course, it's a committee meeting and it's open to the public, as one does. So, it was broadcast. On April the 27th, counsel for LM sent a letter to the superintendent asserting defendants had censored the views in violation of the First Amendment rights by restricting them from wearing the shirt in school. The letter stated that LM intended to wear the shirt again on May 5th. Counsel requested the confirmation that LM would be permitted to wear the shirt. On or about April the 29th, the incident involving the shirt became the subject of news coverage, which included interviews of LM and discussion on social media amongst parents, students, and others about the incident because, hey, people are getting to learn about this censorship environment and the school not allowing only certain views. And the school, should we say, I don't know, the school is only allowing certain views on the topic of transgender, only views that affirm the transgender view, and they're making sure that only those views are provided to the students and taught to the students. And when there's a problem, the school counselor is there to tell them their views are wrong and reinforce the correct views. There's, I think, a word for that. When the adults are trying to create an environment that tries to get the students to adopt a certain belief set that might make them more comfortable with behaviors that might somewhat defy more natural behavior. There's a word for that. I just can't remember exactly what it is. On a completely other unrelated subject, I wonder if anyone has noticed my efforts at grooming myself and whether or not you think I look pretty. Fun and exciting. Okay. On May the 4th, counsel for the public school responded to the council's letter stating that under Tinker, a case I know very well, and Massachusetts law prohibiting discrimination, harassment, and bullying on the basis of sexual orientation and gender identity, the school has and will continue to prohibit the shirt worn by LM or anyone else wearing messages likely to be considered discriminatory, harassing, or bullying to others, including those who are gender nonconforming, by suggesting their sexual orientation, gender identity, or expression does not exist or is invalid. I don't know how that's compatible with Tinker. Also, at this point, I just start wearing a black armband because that's the only way I can get my message through. And maybe just write the word truth on the black armband because the truth has died. See if that gets the point through. Okay. The assistant principal learned of the letter from the principal. I was aware of the concern of the shirt would be disruptive and will cause students in the LGBTQ plus question mark, ampersand, backwards, question mark, squiggly, caret, raised to the power of 5 contingent would be, hurt by the fifis. On May the 5th, LM wore the shirt to Nicholas, but with the phrase only 2 covered by a piece of tape with the word censored on the shirt. Cute. When LM first arrived at class, he was instructed to go to the principal's office. Before the meeting with the principal, LM removed the taped shirt. Okay. All right, let's see. Tucker instructed LM that he could keep the tape shirt in his backpack or leave it in the office for the day. LM put the shirt away and returned to class. He did not wear the tape shirt for the remainder of the day. LM did not witness any disruption or school activities. So even with covering up the two genders, saying there's only blank genders, he's not allowed to wear that shirt. That's cute. On May the 9th of 2023, two other students wore the shirt with the words, "There are only two genders," to the school. The principal met with the students and told them they were required to change their shirts. One student followed the directive and returned to class. The other student did not. The student's parent was called, and the principal met with the student's mother at school. Following the meeting, the student went to the home as school day was over. Neither of the students were disciplined for wearing the shirt with the words, "There are only two genders." Good shit. On May the 11th, the plaintiff filed the instant action under 1983 for a violation of the First and 14th Amendments. LM contends the defendant's application of dress code to restrict the shirt and tape shirt, but not other messages by other students pertaining to sexual orientation, gender identity, and expression, amount to impermissible viewpoint discrimination. That sounds like the magic words to me. Impermissible viewpoint discrimination. You can't allow people to wear shirts saying there are more than two genders, or the equivalent, rainbow flags, or other symbolic speech which clearly communicates that message, and not allow someone to wear a shirt or otherwise symbolic speech that indicates a different point of view, right? If you wear a pride flag, you are expressing a view on the issue. And if you wear this shirt, you're expressing a viewpoint on the issue. So this does sound suspiciously like impermissible viewpoint discrimination to my ear. I have a sneaking suspicion the district court is going to disagree with me massively. I look forward to being frustrated by the district court. Okay, the plaintiff also asserts the dress code is vague and overbroad. I'm not sure about that part, because that sounds like a totality challenge, right? So it's void for vagueness, but you have to be pretty damn vague, right? So it's problematic on its face. I think the as applied challenge is better, but whatever. Let's press on. Okay. On May the 19th, the plaintiff filed the motion for a temporary restraining order. Following a hearing, the court denied emergency relief, so not so much. The court held oral arguments as a preliminary injunction. Okie doke. The issuance of a preliminary injunction before trial on the merits can be held as an extraordinary remedy that shall be entered only if the plaintiff makes a clear showing of entitlement to such relief. That is correct. Injunctions are never afforded as a matter of right. They're not strictly speaking a legal remedy at all. They're strictly speaking an equitable remedy. And they're only to be applied in extraordinary cases where things are really, really clear. Great. In evaluating the motion for a preliminary injunction, the court considers the following four factors, which are the same four factors that we always consider. Though, depending on which court we're reading, you'll read slightly different factors, but they're really the same thing. So this says we're going to look at the likelihood of success, the potential for irreparable harm if the injunction is denied, the balance of relevant impositions, the harm to the non-movement enjoined in contrast with the hardship to the movement, and the effect of any on the public interest. Basically the same four-factor test. How likely are you to win? How bad is it for you if nothing happens? Who's going to be hurt more? What does the public interest say? Which is where the First Amendment, I would think, would come really deeply into this, being a First Amendment right and all that stuff. So fine. The first factor is the most important. If the non-movement cannot demonstrate likelihood of success, the remaining factors become idle curiosity. Fair enough. If you're not going to win, then everything else is a little bit pointless. In the First Amendment context, likelihood of success on the merits is a linchpin. Okay, to demonstrate likelihood of success, plaintiff must show more than a mere possibility of success. Rather, they must establish a strong likelihood to ultimately prevail. Fair enough, right? So we're looking exactly where on the benchmarks we're looking is a little bit vague, right? So we're looking for something between, let's say, 5% and 50%, right? Because if we had 51%, we've just won because it's a civil case, right? So we don't need that much. So if we had 51%, we'd just be done. So we need something more than just the mere possibility, more than 5%. So how much do we need? Depends on which court you're trying to ask, but 25% range, maybe 25%, maybe a little bit more than that, because it's extraordinary remedy and it comes early in the case, right before we have things. So maybe a little bit on the higher side, because we want to make sure that we're reasonably confident, because this is coming in and somewhat interrupting the natural flow of the process. Okie dokie. All right, so likelihood of success. A student's right of freedom of expression while attending a public school in Massachusetts is defined by the Supreme Court and the First Circuit. First Amendment rights applied in light of special circumstances of the school environment are available to teachers and students, so says Tinker. Yes, it does. For the state, in the person of a school official, to justify prohibition of a particular expression of opinion, it must be able to show that its action was caused by something more than mere desire to avoid discomfort and unpleasantness that always uncovers the unpopular viewpoint. Right. More than mere desire to avoid discomfort and unpleasantness. Right. We don't need the First Amendment to protect popular speech. That's not the point. So it necessarily will be unpopular speech, because otherwise, why are we even talking about it? It would just be allowed. And for the school to act, it must be more than a mere desire to avoid problems. It has to actually result in problems. Okay, fine. Great. But First Amendment rights of students in public school are not automatically coextensive with rights of adults in other settings and must be implied in light of the special circumstances of a school environment. Okay. A school not need tolerate student speech that's inconsistent with the basic educational mission, even though the government may not censor similar speech outside of school. Well, fine. To some extent, I think that this is broadly true of pretty much governmental operations in general, right? So a person cannot exercise their First Amendment rights in a way that would fundamentally disrupt the governmental operation in play, because that would be a burden on everybody. So I don't know what a good example would be, but let's suppose you really hate the DMV, as some people do, right? You could express your view that you hate the DMV. You could even protest, on the sidewalk outside the DMV, but you couldn't go into the DMV and have a protest in there, like time, place, manner restriction, if you like, right? This is the wrong place for this, because we're trying to conduct business here, and we're sorry that you're upset with the DMV and all, but take it outside and talk to the press, talk to the media, whatever, like that. So I think that's sort of what they're talking about, right? We don't want students to express views in the classroom that would fundamentally undermine the teaching environment. So the school's got to be able to school, right? Basically, a bottom line. School's got to be able to school. Okie dokie, that sounds fine. So while students do not shed their constitutional rights to freedom of speech or expression of the schoolhouse gaze, schools may impose limitations on speech. To some degree, yes, but I have a feeling you're about to somewhat misunderstand what the upper courts had in mind here. Conduct by the student, okay. Conduct by the student in class or out of it for any reason which stems from time, place, or behaviorally, materially disrupts classwork or involves substantial disorder or invasion of rights of others is not immunized from guarantee of freedom of speech. Well, if it's conduct, I don't know why we're talking about the First Amendment at all. First Amendment doesn't protect conduct. It protects speech. So if you're engaged in conduct, then, they can discipline you because you're engaged in conduct. So, you can't, interfere or, terrorize people or stuff like that, but, okay. Yeah. So fair enough. If it is conduct which stems from time, place, or manner behavior, which disrupts classwork or involves substantial disorder. But even here, right, materially disrupts classwork, involves substantial disorder, right? We're still looking to actual things that actually occurred, not hypothetical. We're looking at actual disruption, actual disorder, actual invasion of the rights of others. We're looking for something actual, not hypothetical. So yeah, that's not immunized from constitutional guarantee of freedom of speech. I'm not sure that it's immunized for an adult either. Your right to swing your fist stops at someone else's nose, as the famous saying goes. Okay. This interest in regulating speech is at its strongest when the speech occurs under school supervision, where the school stands in loco parentis towards all students, and lesser interest when speech or expression occurs outside school, citing BL versus Mahoney. Okay. While school bears a burden of justifying restriction on the speech, courts should be generally deferring to school administrators' decision regarding speech so long as the administrator's judgment is reasonable. Ooh, I don't know about that, but okay. All right. Plaintiffs contend that he is likely to prevail on his claim the shirt was constitutionally protected speech, and defendants' enforcement of the dress code impermissibly restricted First Amendment free speech rights, constituted viewpoint discrimination, which it clearly does. It clearly does. This is the biggest thing for me, the viewpoint discrimination. Like, that's the thing that I'm like, you just can't do that. And for that proposition, I cite Texas v. Johnson, the flag burning case, right? You can't do that. You can't allow certain viewpoints and not allow other viewpoints. So if the topic is so problematic that you have to ban all expression of the topic, which, fine, but the viewpoint discrimination is the biggest thing that's getting for me here. Thank you for the super chats, or the gift memberships rather, Marie Z. I do appreciate all the people who help to support this channel financially. As always, just a kind reminder from all you guys to hit that join button or the link that the bot gives you from time to time. And you can always, of course, send a super chat my way. All your support does help the channel grow. There are significant expenses in maintaining this channel to make sure that it works as good as it can. And I really do appreciate everyone who helps me. Thank you, Mandrake, for hitting that beautiful, beautiful join button and being one of the special shiny people. It is appreciated. It's only 99 cents a month. Moving on, plaintiffs assert that defendants have not met their burden of demonstrating the shirt caused a material and substantial disruption when defendants assert only a few unidentified complaints were made, or the shirt invaded the rights of others, which the student did not target a specific individual. It doesn't disrupt the rights of others. Other people can engage in their own speech. It doesn't disrupt anyone else's rights. Defendants do not dispute the shirt may be constitutionally protected speech. However, they assert the restriction of the shirt was justified where the administration received complaints from student and staff, and the shirt invaded on the rights of trans and gender nonconforming students who are protected class. It doesn't infringe on their rights. They have as many rights as they did before. His shirt does not infringe any one of their rights. Plaintiff has not established a likelihood of success with the merits, where he's unable to counter defendants showing the enforcement of the dress code was undertaken to protect the invasion of rights of other students to a safe and secure educational environment. If you could show there was actually a problem with safety, if you could show there was actual disruption, then yeah, but there's no indication of that. You are just concerned about the hypothetical. You're just concerned about the fifis and the feelings and making sure the protected viewpoint gets through and no other viewpoints. They might be a protected class, but that doesn't make their viewpoint legally protected. That's insane. Nor does it make speech against that legally unprotected. That's not how protected classes work. And even if it was how protected classes work, protected classes are a matter of statute, not constitution. This is all dumb. School administrators were well within their discretion to conclude there are only two genders may communicate there are only two gender identities, male and female, are valid, and any others are invalid or non-existent, and conclude students who identify differently, whether they do so openly or not, have a right to attend school without being confronted by messages attacking their identity. But how was the message of the gay pride not attacking his identity? Because, okay. As Tinker has explained, schools can prohibit speech that's collision with rights of others to be secure and be let alone. If there is actual disruption, yes, you are misunderstanding and misapplying Tinker. You're a bad district court. Plaintiffs contend that under relevant case law, the district could not restrict the shirt as an invasion of the rights of others unless a determined speech targets a specific student. Norris, however, did not attempt to set a rule for all speech as an invasion of the rights of others or the precise boundaries of what constitutes bullying such that falls within the invasion of rights of others. And there's a footnote. Elam attests that he does not believe his views about sex and gender to be inherently hateful and does not intend to deny any individual existence. His intent is not relevant to the question of whether the school permissibly concluded the shirt invades the rights of others. Okay, so my audio died. My audio died. It happens. So I'll just go back up to the previous start of the paragraph. Instead, it's not my fault. It wasn't me. It was the app doing its thing again, as it sometimes is wont to do. It pisses me off. Instead, the prior case law concluded that where a school had justified the limitations on student statements that there is a rapist in our school and you know who it is on the ground the student had engaged in bullying, the school was required to demonstrate that it had a reasonable basis to determine the speech target a specific individual. So in a prior situation where someone said there's a rapist in our school and you know who it is, that speech was protected. That speech was protected. This speech is not protected because here the school's rationale for prohibiting the church is not that LM is bullying a specific student, but that a group of potentially vulnerable students will not feel safe. Now, notice the difference here. Notice the difference here, right? We've moved from LM is bullying to vulnerable students will not feel safe, which is not the same thing at all. So the problem isn't even, in the court's view, that LM is bullying. That isn't even the problem in the court's view. The problem is that students will not feel safe. So his actions are irrelevant. Their feelings are what matters. Wow. Fun. A broader view directed at student safety has been acknowledged by other courts. Holding the display of Confederate flag may interfere with the rights of others to be secure. Recognizing school officials may suppress speech that is vulgar, lewd, obscene, or plainly offensive. Well, this isn't any of those things. There's only two. You're telling me there is only two genders is the equivalent of displaying the Confederate flag? Or is there's only two genders is vulgar, lewd, obscene, or plainly offensive? That's where we're at right now? That's what you're telling me? Holy shit. Holy shit. Accordingly, plaintiff has not shown a substantial likelihood of success on his claim that the defendant violated his rights in requiring him to remove the shirt at school. Plaintiff contends he's likely to prevail on his claim. Defendant also unconstitutionally restricted his speech when he wore the tape shirt to school because the underlying message was constitutionally protected speech, and the tape shirt was a form of constitutionally protected protest of defendant's censorship. Defendants respond the underlying message was not constitutionally protected speech. Well, actually, you said earlier that you thought it was. So this is page 13. And hold on. On page 10, the court says defendants do not dispute the shirt may constitute constitutionally protected speech. So on page 10, defendants do not dispute the shirt may be constitutionally protected speech. On page 13, the underlying message, rather, defendants respond the underlying message was not constitutionally protected speech. So two pages ago, they didn't dispute that it's constitutionally protected. But now they say it's not constitutionally protected. How exciting. And plaintiff's use of the tape on the shirt merely covered part of the offending message while still conveying the same meaning and raising the same concern. So presumably the black armband would also be banned. I'm not sure how on page 10 defendants do not dispute that the shirt may be constitutionally protected speech. And then on page 13, defendants respond the underlying message was not constitutionally protected speech. How does that work? How does that work? Plaintiff is unable to demonstrate a reasonable likelihood of success on the merits where defendants have shown they've restricted the speech based on their expectation it would be to intrude on the rights of others. First, as discussed above, the original message of the shirt was not protected speech. So the court thinks it's not protected speech now? Really? Okay. Second, while a message protesting censorship would not invade the rights of others, the school administration could reasonably conclude the tape share did not merely protest censorship, but convey the censored message. Wow. This court is special. This court is special, not in a good way, man. So even wearing a censored shirt conveys the sense. So you're allowed to protest the censorship, but not in a way that actually conveys the underlying message. This is some bullshit. To the 400 of you who are currently here, by the way, thank you for turning in for this somewhat impromptu and unannounced stream. I appreciate that all of you are here and joining me today. We had a good day today, or at least I had a good day today. We did some chicken wings, which, at least in my humble opinion, turned out very, very tasty. I have now eaten all the chicken wings. I'm going to make more chicken wings, and I'm excited about that. And also, on a personal victory, I went to the gym today. It was actually my 5th day of going to the gym this week. That was nice. I did really good work today. And I lifted more than 35,000 total pounds today. That was nice. So I achieved a lot of victories for myself this week. I also bought the face powder that people were recommending. That Wet n Wild face powder, I put some on. And so I hope that's helping a little bit. And it's making me feel all warm and special inside. So all those things are just going well. And I'm in better spirits. And I'm in better spirits. Things are good. Sandra, would you take care of that, please? Plaintiff contends that he's also likely to show the dress code is facially vague and overly discretionary when it targets some speech and not others. Plaintiff points to dress code application to protest on May 5th as an illustration of how vague and overbroad the dress code is on its face. But the example does not support his claim when defendant could have reasonably found the tape shirt would interfere with the rights of others. Literal tape is now interfering with the rights of others. It's going right. Nor is plaintiff overbreath challenge likely to succeed when the dress code does not threaten discipline for violation of the dress code that has not been specifically identified by the school as improper. To the contrary, the dress code provides that if students wear something inappropriate to school, they'll be asked to call their parent guardian to request more appropriate attire. Only repeat violations are disciplinary. Accordingly, elements failed to demonstrate a likelihood of success on the merits. Lol. LM has not established a potential for irreparable harm absent a preliminary injunction. LM contends that any deprivation of his First Amendment freedoms constitutes irreparable injury. One would imagine, oh my God, no, we're not doing mute again. Oh, thank you. You're behind. LM contends that any deprivation of First Amendment freedoms constitutes irreparable injury. Thank you, Jennifer, for the gift memberships. And that when he made a strong showing of likelihood and success on the merits, the irreparable injury component of the preliminary injunction analysis is satisfied as well. However, where the courts conclude plaintiff has not demonstrated a likelihood of success, and plaintiff argues no other arguments as to potential for irreparable harm, plaintiff has failed to establish the prong of preliminary injunction. A lot of good stuff. I don't care. I don't care. Sandra, ban Ben, please, if you haven't already. Ban Martin, please, if you haven't already. I'm not tolerating this shit anymore. Go to hell. The third prong of the preliminary analysis, the balance of equities between the parties cuts in defendants' favor. As to the harm of LM absent the injunction, there's no doubt defendants have restricted LM speech during school hours. However, this is not a circumstance where restrictions are such that LM cannot engage in the kind of speech at all. Wow. That's neat. That's neat. Although LM speeches to specific messages displayed on the shirt has been restricted while at school, LM has been and remains free to convey his message elsewhere. In fact, his message has been amplified through social media, news outlets, and this litigation. Furthermore, LM has not been restricted from other speech while attending school. He's worn a variety of messages and can view his voices elsewhere. All right, fine. I'll take care of it myself. Since apparently we're having moderation problems over here for some reason. Fine, I'll do it myself. Oh, Lord. Great. Let's see. Where was I? All right. And incidentally, was someone put on the time pause, Sandra? If you haven't done that already, please. I don't think I did it. It's actually harder for me than it is for you. Rose, I wasn't asking for a consensus. I was making a direction as a channel owner, but thank you. Let's see. Defendants, by contrast, contend that were the injunction an issue, the hardship defendants and students at Nicholas would not be insignificant. First, defendants contend the shirt would cause harm to students who identify as transgender or gender nonconforming because it would prevent them from attending school without harassment. Second, defendants contend that were plaintiffs permitted to wear the shirt, defendants would fail to comply with their mandate from the Massachusetts legislature prohibiting bullying, discrimination, or harassment in schools based on gender idea and expression, and directives from the Massachusetts Department of Elementary and Secondary Education, which require that schools provide a safe environment to progress academically and developmentally, regardless of gender identity. Fun and exciting discrimination over here. Goodbye. Goodbye, R&M. It was nice. Thanks for playing. The balance of hardships cuts against requested relief. While a plaintiff may experience some limited restriction in his ability to convey a specific message during the school day, absent injunctive relief, or an injunction to issue, the courts credit defendant's contention that other students' right to be secure and be left alone during the school day would be infringed upon, or defense ability to enforce policies under state law and regulations. Accordingly, the prong against plaintiff violates the requested relief. All right. This is so hilarious. Conclusion: for the foregoing reasons, all preliminary factors enjoined. This is such bullshit. This is such bullshit. District court is wrong on this. So I suppose there will be an immediate appeal to the First Circuit, but I wouldn't depend on the First Circuit reversing this either. The First Circuit's in it, so maybe we'll try to you know, we'll try to get this to the Supreme Court and see if the Supreme Court wants to do anything about it, but I wouldn't depend on that either. So yeah, this court is just wrong, in my humble opinion. They are very, very wrong. Bad legal analysis all the way around. So yeah. Yeah. Good times. So that is the end of that for the moment. This is Massachusetts, not California. Not that it makes much difference, but this is Massachusetts. Yeah. So because it's an injunction, you can appeal it to the First Circuit, but the First Circuit's not going to do anything about it. Yeah. It's bad speech because it targets a protected class, I guess. Yeah. Okay. Just checking my Discord to see what else is blowing up in my world right now. Check my fan funding. That's a good call. Let's see. Oh, did you send me stuff on that, Sandra? No. Let's see if I can get about this way. Mary Z gifted 10 gift memberships. Mandrake became an uncivilian. Jennifer gifted 10 gift memberships. Just Me has been a member for 8 months. Those are all the support messages I see recently. The judge did mention Tinker Demoy. Kind of blew right past it for all that. Wonder how the court would feel about a shirt that just said XX and XY on it. Funny. I do think I know better than Alan Dershowitz, as a matter of fact. Alan Dershowitz is a hack. Yeah, Alan Dershowitz is a hack. For them to oppose XXX, why they have to oppose science? Does Alan Dershowitz have wrong opinions often? Yeah. Oh, Mandrake gifted 50 gift memberships. Thank you, Mandrake, for gifting 50 gift memberships. That's very kind of you. Yeah. Thank you, Mandrake, for gifting 50 memberships. That's right. I can see it in the title. Thank you. I missed it earlier. I'm sorry. Thank you very much for your strong showing of support to the channel. It's very, very much appreciated. Can I think of any issue similar to this issue? I mean, Tinker, BL versus Mahoney strike me as similar. Uh, we get that on Alan Dershowitz is a hack, maybe. Yeah. Alan Dershowitz is a hack. Lawrence Tribe has gone off the deep end. Rudy Giuliani lost his mojo. Yeah. How can schools teach these lies with a straight face teach biology? I don't know. That's a good question. That's a good question. I wonder if he could literally just wear a pride flag with a circle and a line through it. Wonder if he could do that. I mean, they allow the pride flag, but can he wear a pride flag with a circle around it and a line through it? That would be interesting. Maybe we should give that a try. What if you wore a shirt that says "What is a woman"? There you go, man. I should just get some shirts that say "What is a woman" for my own thing. Oh, one of you guys sent me a picture of one of my stickers on a mug. Let me see if I can find it because it made me happy. Oh yeah. Let me see if I can share this real fast. I do have stickers on my shop, and someone bought a sticker and put it on one of their glasses at home, and they sent me a tweet about it earlier today, a DM, and it made me happy. So here's a picture of someone who's gotten the uncivil law sticker and put it on their tumbler and drinking uncivil law tumbler as they watch their TV and stuff like that. I thought that was really, really cool. So if you'd like one of those things, you can get it through my merch store. The bot tells you about the links from time to time. Get stickers, some shirts, and other stuff like that. So that's available if you'd like that stuff. I thought it looked really, really cool. Yeah. So we sell stickers and some other things. It's been a while since we took a look at my merch store. Take a look at it. Find a link for it. Oh, there it is. Yeah. So we have some merch. It's not very fancy, but we do have some merch options. Kiska, you emailed the Uncivil Law LLC email? Okay. Um, I check my email pretty frequently. I might have ignored it depending on what it is. Um, but here's some merch we have. Little hooded sweatshirt there. Learning from the misfortunes of others. Laws are the original memes. All the no. And these come in different colors, right? So here it is in blue, but you can get it in orange, or pink, red, yellow. You get your choice of color there. And you get athletic shorts with them. Get some stickers. Here's one with a shirt, hat, embroidery patch. So some basic stuff, but if you want some of that stuff, we got some options. I'm not very good at the merch design, but some basic stuff. Have I weighed in yet on the trial of the school resource officer at Parkland? Yes, as a matter of fact, we've been covering that trial every day. We've been covering it live every single day in the mornings. So we've been covering that trial as it happens every morning and every afternoon. We've been covering the entire thing. So far, the state has not really, to my mind, demonstrated very well as to what the officer did in terms of things. They've brought in a lot of emotional testimony, but haven't really spoken to the defendant's actions. They keep alluding to the defendant being like cowered behind a car or something for 40 minutes, but they haven't actually done that. So, all the rest of it, you know? So, good times. So, yeah. And it's been interesting to watch for sure. Wearing a Solifist t shirt, that's pretty funny. Covering the Trump trial, if I could, it's federal court, so there won't be any live streaming, but I'm not necessarily opposed to getting my ass down there and going in person. Now, I imagine that getting into the courtroom is going to be really, really difficult. But then again, there might be some overflow room with some sort of closed caption or closed loop television or something. So, depending on situation, I might try to go down there in person and watch the thing and then report in person. But that's a long way from now. I don't think that the Trump trial is going to happen anytime in the near future. Yeah. So we'll see. But I wouldn't. We'll see what's going to happen. If I have to wind up having to go down there in person and stand in line on the cold cement for like hours at a time every day for weeks on end, I'm going to be a very grumpy uncivil. We'll see how that all presses out. Southern District. It might be Miami. I'm not sure exactly where it is. It's sort of a. We'll see. Yeah. All right. I guess I'm going to sign off for now because we've run out of things to talk about. But I've enjoyed being here. We'll be back on Monday, of course. We won't have trial on Monday because the court doesn't have trial on Monday, but we'll have legal news roundup on Monday and also on Wednesday because the court isn't in session on Monday. We'll be back on the trial on Tuesday and then Thursday and Friday. And presumably, I think there's opinions being dropped from the Supreme Court next week as well, probably some big ones. So that'll be fun. And we'll do that. And hope everyone's having a great day. I certainly am. And I'm looking forward to another week, hopefully, of some great workouts. We'll see how that goes. I've been on Civil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.